Good afternoon, everybody. I think we'll get started on the afternoon presentation. I remember a few faces from the morning. I'm Brad Dagan. I'm an attorney. I perform a lot of construction law, construction litigation. I represent about 50 builders, quite a few subcontractors, and a variety of real estate people. At this point in our presentation, I've been asked to talk about some really exciting documents. So if any of you doze off, I have a pretty good throwing arm, so I might pop you with something just to keep you awake. But there are some good forms that we've been working on at the Metropolitan Builders Association, and I think some of them we'll be talking about this afternoon. Obviously, this morning we've talked about the new home contract as well as the remodeling contract, and then I think Kim Hurtado talked about the specifications, which have been updated. We recently had a committee that was put together to update the forms, and I think the fruit that you see is in your folders. I don't have an outline for the afternoon session on it, unless any of you want my copious notes and my outline on my discussion points here. But the main thing I'd like to cover first off is the trade contractor supplier agreement, which is hopefully in your packet, and you may have that handy. I'd like to highlight a few of the main things in that document. This form evolved a few years back based upon the concern among the builders and the suppliers that we did not have a standard form to guide the relationship between the builders and the remodelers and the subcontractors. As you can tell by looking at this form, frankly, it is a little bit long, but it's been designed to be an inclusive roadmap that helps guide both parties in the contract process, both the builders and the suppliers and the subcontractors. So essentially, I think what we can gather out of this document is that the form that you see in front of you, I think mainly is designed for perhaps the larger contractor who deals with multiple projects during a given year. This contract, the first page of the document has some basic information about the parties and the relationship between the parties, and I think it sets out in the preamble some of the basic goals of the document. First off, obviously, there's the trade contractor prefers blank days notice before the commencement of trade contractor's work. That clause got in there in response to the subcontractor concerns that they were never given enough advance notice of when they needed to be on the job. And this is not particularly binding given the fact that it's a preferential type clause, but hopefully the builders and the subcontractors, suppliers, refer to that and kind of use that as a guide to try to have good scheduling for projects so that everybody's happy at the end of the day. The other important component in that preamble section is that the trade contractor, who is basically the subcontractor or supplier, has been asked to recognize that change orders, purchase orders, and job sheets may be forthcoming, and that could be that is important because that helps to define the scope of the trade contractor's work. Again, this form that you see in front of you is kind of a generalized form that sort of guides the overall relationship between the builder and the subcontractor. And when I say subcontractor, I do want to include suppliers, so if I just abbreviate that to subcontractors, I'm not trying to leave suppliers out of the picture. But ultimately, this document focuses on starting the relationship between the parties. It's anticipated that this would be sort of a long-term relationship between a builder and a subcontractor, and that it refers and incorporates by reference the terms and conditions. And then in that document, which starts on page 2, there's specific language pertaining to the scheduling, which is item number 1. As I mentioned, I think scheduling always seems to be one of the key areas of problem between the builder and the subcontractor. So this document attempts to define that relationship. And also the quality of the work. Again, we refer to the construction industry quality standards, which dovetails into the builder's responsibility with the customer. These documents generally guide, obviously, the relationship between the subcontractor and the builder. And because the builder is held to industry standards, the builders are now trying to, in turn, hold the subcontractors to our industry standards. There's a few other important points in here. Obviously, number 2 becomes important because the subcontractors, we'd like to make sure they stay as independent contractors. Even if they solely work for one builder, you can still maintain that independent contractor relationship, which does have important tax and liability considerations. Item number 5 I'd like to point out deals with safety and specifically references OSHA. This imposes a burden on the subcontractor to be OSHA compliant, which frankly I'm seeing more and more OSHA enforcement. I'm not sure how you guys are seeing it out in the field, but I've had a number of clients, especially roofers and a few other builder clients who have had spot OSHA inspections, even just drive-bys where they are kind of tooling around neighborhoods and looking for properties to inspect. I'm not sure what the impetus is for the increase in OSHA inspections on residential construction, other than the fact that maybe commercial construction's a little bit down, which has historically been their focus. But we definitely need to pay attention to safety requirements. I mean, I had a client recently who had some laborer out on a job just finishing some cleanup on a roof, and he actually was up on the roof, just, I don't know what he was taking off of the roof, but they got a $10,000 ticket. We were able to get that reduced, but OSHA likes to start out in a big way before they eventually negotiate to something a little more reasonable with their fines. The guy on the roof didn't have a harness on, so they got issued the citation. Another thing that we sometimes see is care of the materials. So the terms and conditions try to specify responsibility for that. The trade contractor has to, take care of the materials provided by the builder. Don't leave them out in the rain, especially, if it's wood flooring material. We don't want to have any disagreement or disputes arise out of that. On page 3, another thing we are trying to regulate with this document is contact between the subcontractor and the homeowner, because frequently there are complaints about the subs soliciting work from the homeowners. So this is somewhat of a specific clause in here to try to basically tell the subcontractors, you can't negotiate with my customer, at least for a period of time until after this project is done. And in fact, we have a 1-year clause in this particular document where the subcontractor agrees to not solicit any business from the homeowner for a period of 1 year. Warranty is in section 10. That becomes important because, as you know, the builders and remodelers have to warrant their work, so in turn they want decent warranties from their tradespeople. And essentially what we have in here is a warranty that mirrors the warranty that the builders have to give to their customer, and in turn the subs have to warrant their work for the 1 year that the builder has provided a warranty to the owner. 11 is an important thing too. It helps guide the relationship. It's the failure to complete. If for any reason the subcontractor fails to complete their work on a project, the goal of this provision is to first of all spur them on to finish their work, and secondly, in the event a subcontractor just does not finish their work or bails off a job for any particular reason, this gives the general contractor or the builder the right to finish that work and then charge it back to the subcontractor. Now there's a few other provisions in here. Similarly, this document requires insurance from the subcontractor, naming the general contractor as an additional insured. We may want to edit this to add the general contractor as a loss payee for those remodeling contracts where we can't name them as an additional insured, but that's a note I'll run by our insurance people. But ultimately, again, just as with the builder and the homeowner having responsibilities between each other for insurance, this guides the relationship between the trade contractor and the builder. Should any disputes arise, there's a mediation and arbitration clause in section 17. And just in general, these are written terms that I think somewhat incorporate the existing practice that was more the handshake deal prior to a written document or agreement that's been presented as between the builder and the trade contractors or suppliers. Now the way this document works is that there's a pricing addendum which should also be attached. While we have the general terms and conditions as the first part of the document, page 5 is the pricing addendum, and that really governs a specific project that's at hand. And ultimately, again, this document presupposes that there is an ongoing relationship between a builder and a subcontractor, and I'll hit that in a minute. So if you have a one-time sub, this may not be the best document for that particular purpose, although it's still workable. It just has to be remembered that this document is designed for, I think, a company that builds more than one home a year and that has an ongoing relationship with a subcontractor, such as an electrician or a plumber. So if you have a good relationship with your plumber, you don't re-sign this whole document every time there's a new project. Instead, the pricing addendum comes into play where the specific project, so if there's 4 houses a year, you'd have one basic trade contractor and supplier agreement, and then you would use the pricing addendum to set out the particulars for each project as between the builder and that sub. So if you have the Smith house and the Jones house, then you have 2 separate pricing addenda, one for each house, and those incorporate the plans and specifications for that particular project. There is also available an Addendum A as part of all these documents, which set forth additional special conditions. If it's a specialty product or something of that sort, you can use that form to lay out those special conditions. Looks like there's a question in the back.
Yeah, so we only have to do this once every year or once, and then you can use this for every project?
I would tend to have it re-signed once every year, just so you can sort of force the company to follow through, make sure the subcontractor provides an updated certificate of insurance, make sure the working relationship is good and up and running. This is an at-will relationship, but this document will bind the relationship between the parties so long as you keep giving the subcontractor work. So I think it would be good to kind of have like an annual review of the trade contractor agreement, just to kind of see, sort of a state of the union once a year, see how things are going. So that's my recommendation. It can be an ongoing document. You don't even really necessarily have to sign a new one, but I would definitely go through it once again, particularly when it comes to insurance, review the safety track record, even review the performance of that particular subcontractor, just to make sure they're doing what you want them to. Yes, did you have, Bob?
Does this work for also remodeling as well? If the sub is doing both for you?
Yeah, I think it's a little bit tailored more to new home construction, but it definitely works. The very similar terms and conditions apply. So I think this agreement could be used certainly in the remodeling context. It's just, it might require a little more variation or some special conditions for remodeling. But at the same time, overall, the same concerns I think are found between the builders and the subcontractors in the remodeling context as we find in the new home context. So this is really designed to kind of pinpoint those areas of issue or kind of battles in the past between the parties and lay out, here's the roadmap for a good relationship between the builder and the subcontractor. So I think it would apply equally in the remodeling context. And I think I would just, review it once and make sure that all those terms apply to those, that type of a project. Frankly, I think one of the best trade contractor agreements I've seen in a while was a 2-page fax that I have to admit, my client did the template for it, and I just tweaked it a little bit, incorporating all the major bullet points that we just went over relative to the trade contractor agreement. But I think one concern I've heard is that this trade contractor agreement is too long, we don't know how to use it. And I think for an ongoing relationship, it's probably going to work just fine and people will understand it and be able to work with it. But for a one-time use, sometimes some of the builders or the subs usually will balk at signing a document that seems so onerous to them, when in fact if they read it, maybe they would see that it governs the relationship and some of the issues that they've had in the past. But what my one client did is they took all of those concepts and made it into sort of an outline and sent the fax out with a signature line to their subcontractors and had them sign it and send it back. So it's got all of the critical items, but it's down to 2 pages, so I guess the subs were less threatened by 2 pages than they are by 6, even though it kind of says the same thing. For example, the first item here is all work must be done in accordance with the plans and specifications dated such and such a date that have already been provided to you. And then my client says that they'll contact you in advance to work out scheduling, and we'll give you at least 1 week's notice. Then we say they agree to be an independent contractor. Here's a couple of things that I think are important. There will be no deviation from the plans and specs unless signed by Silvercrest was the company, and the customer, which I think is important because sometimes you see changes made on the spot by the customers, and there is essentially this clause is that there will be no deviation from the plans and specs unless the builder signs off and the homeowner, and this was a remodeling job. So there with the homeowner signing off and the builder signing off, then the sub is good to go. Sometimes, as you all know, the homeowners talk to the subs and say, hey, can you add a couple of can lights, or can you upgrade this plumbing fixture, you know? And so the subs frequently have found themselves in the middle of a tug of war where the builder needs to make sure that extra cost gets passed through to the owner, and yet at the same time the subcontractor wants to make sure the homeowner is happy. So there have been times where the subs will say, okay, yeah, sure, I'll make sure that happens, but they forget to talk about the pricing part of it because they just will do an extra back to the builder, and then the builder sees this extra invoice and doesn't quite know what to do with it because they said, hey, I didn't, you know, the homeowner didn't contact us about those 6 extra can lights, you know, now what do we do? So I've had, you know, clients actually eat some of those extra costs just to keep the homeowners happy. But here the goal is to not allow the subs to be your middleman or be your expediter or be your office manager, where you try to get the homeowner, and this is good for the subs too, so they don't have to worry about being stuck in the middle. But it's important, I think, that the communication goes from the homeowner to the builder instead of from the homeowner to the sub to the builder on any extras or changes from the basic contract. You know, sometimes fast action is needed, but at the same time, the sub should tell the homeowners, hey, I have a specific provision in here, and it's in the trade contractor agreement as well as this short version, that the subcontractor must contact the builder, but at the same time the homeowner is told, don't go through the sub, don't order anything through the sub, and the sub should repeat that to the homeowners by saying, you know, any changes you want, you have to talk to the builder. And here we just say no exceptions to that, so that the subcontractors understand that if they actually agree to an extra or a change, that they could be held responsible for that. And we kind of went one step further on this one, that only the bid estimate will be paid. There is language in the trade contractor agreement. It's not quite as point blank or blunt, but here it's only your bid estimate will be paid, no exceptions. So I think we can find all of this language in the trade contractor agreement, but for like the one-time use of a sub, or for some subcontractors who are not as sophisticated as many of the larger companies are, the shorter, more direct approach might be a better route to go. So I think one thing is, just in preparing for this presentation, kind of one takeaway I have is that I'm going to maybe talk to our committee on contracts and say, you know, the trade contractor supplier agreement is great for an ongoing relationship because you just have that one-page pricing addendum, and once the parties understand the relationship and agree to the terms and conditions in the trade contractor main body of the contract, then they can just go on their merry way and only have to deal with the one-page pricing addendum as each project comes along. But for the one-time subcontractor, it seems to me that maybe a shorter version of that agreement might be something we should look into. Well, on behalf, essentially this trade contractor agreement is between, and in this document, the GC is the general contractor who is the builder or the remodeler. And on behalf of the trade contractor, we have to figure out who the responsible person is who has authority to sign it.
That's the question.
So what you have to figure out is who's in charge at your subcontractor.
Yeah, am I going to have to go to the owner of the lumber yard?
And well, you'd have to talk to your salesman from the lumber yard and say, do you have authority to sign this agreement? If not, you better put us in touch with somebody who can sign this agreement, because it's a little bit, you know, obviously this is a significantly enhanced purchase order is what it amounts to, with some details, And I'm not sure that a salesperson will feel comfortable signing it. They may say, oh, I got to talk to somebody who's in management or one of the owners. So, and that is one of the concerns I have in the length of the document. But as we go through it, I think for the vast part of the document, it really flows from existing practices that are sort of the handshake deals. And this document has really arisen out of a request by both subcontractors and builders to more specifically define the relationship so that there isn't confusion and an opportunity for misunderstandings. So again, like with a lumber yard, this might be a good example to have the longer agreement with the lumber yard, and then on each particular project, instead of a purchase order or an invoice type situation, then you just have the pricing addendum, or you ask them to kind of work with you and adopt your pricing addendum as the purchase order, because then ultimately for each particular job, you would have a separate pricing addendum where, let's say you order trusses. This pricing addendum would work out great for that, because you would specify and attach plans and specifications or refer to them, or specify what you're asking the lumber company to do for you. Oh, question in the back, or Bob? Well,
why do you even need a pricing addendum if you've always got a deal cut with the guy, whether you're the supplier or a mechanic? As long as you've got this document in place, why do you need that?
Well, I think for your ongoing relationships with people you know and trust, that's great. But if you have new people enter into the picture, or if salespeople come and go from some of the subcontractors, this helps because the pricing addendum is more specifically for each particular job or each particular order.
But I mean, if you have, even if it's a one-time deal, what's the difference? If he furnishes you the insurance and he does the work and you've got a contract signed already, what do you need this for?
Well, the first part of the trade contractor agreement doesn't get you the specific order. So you could use that, and instead of a pricing addendum, you call them up and order, trusses and so on, and you might have a purchase order then, and then ultimately an invoice. So the purchase order would really replace the pricing addendum as the price for that particular project. So I think that certainly could work too, and with. But I guess the general recommendation we have is to try to firm up the dot the I's and cross the T's with the basic document itself. And that's kind of our goal, is to try to avoid any confusion as to who's responsible for what.
But it's really not the price of anything, it's the performance and the behavior on the subcontract when he's on the job site, no matter where it is.
That is the main focus of the document, is definitely that. But I think for some relationships where there's been chaos in the past, I think the goal of this document is to come in and establish the ground rules that I think most builders just kind of assume are there. But I think once again it goes back to maybe replacing the handshake deals with something that's a little bit more structured. So that's, I think, the basic goal of the document. And I feel it does serve that purpose, and while I would certainly agree that you don't really need the pricing addendum if you're happy working with the builder or the supplier and they give you a purchase order and ultimately invoice you, you really don't need the pricing addendum or addendum A at that point, because any details would likely be set out on the purchase order for your particular project, where if you had to change in some kind of anyway, you'd have the specific details tailored to the plan and the specifications for that job. So I think ultimately, I think it makes sense to start with the trade contractor agreement for that situation. But really in practice, if you're using a purchase order system, you can easily substitute that for the pricing addendum. You had a question in the back?
Can you take the contractor agreement to the subs at any time, or does it have to be attached to a plan? And if I have all my existing subs, if I say I want to walk this over to them all next week, can I do that?
Yeah, that's kind of the goal of the document, is to actually go ahead and do that, because it's essentially designed to lay out the roadmap of how the relationships is going to work on a project-by-project basis. And then once that is all signed up, then once you start giving out the projects, then it becomes more manageable. Let's say, just offhand, let's say you have 4 homes a year, and then you go back to the pricing addendum so that only once a year, or even you don't really, like we talked about before, you may not have to even renew this trade contractor agreement. I think it makes sense to review it once a year and just kind of sit down with the subs. But then it goes back to what Bob Flanagan was saying, was that, well, I don't know that you really need the pricing addendum if you have a system in place for purchase orders. And I think ultimately that's where this really, the pricing addendum came from, is that it brings into mind the purchase orders, but what we're trying to do is get away from the old concept of just verbal agreements or things that where confusion could result. And so eventually we have a little bit more structure, and I think it sets out the ground rules a little bit better than what's the past system of just usually hit or miss. Most of the time it works, but if it doesn't work, then what do we do? So in response to some of the confusion in the past, we kind of came up with this document a few years ago just to see if we could maybe restore a good working relationship, set the ground rules so there's no confusion, have less friction between the subs and the builders, and ultimately create that structure so you can go ABC and it's all set into place. But I think you hit it on the head. You could meet with them right away, talk about this as, hey, we saw this form. It lays out the roadmap for how we do business together. And then for each job, we'll do a separate pricing addendum or a purchase order. And then we'll just roll from there. You have
Is there a spot that says 1 year, so that, you got this agreement, with your subs and that, and then a year and a half, 2 years, 2.5, so you're not doing that much, right now, that's will
Sure.
be a good agreement, or how long is this agreement really good?
Yeah, I think this is, there's no termination date, and I think mainly because you have a separate, this is a general understanding that if we do business, this is how we are going to do business, and when we do business, we'll do the pricing addendum or a purchase order, and there's no termination date in here, so essentially it becomes sort of an at-will agreement. But again, if you keep operating under the agreement, it becomes binding on the parties, and if everybody signs it and keeps going forward, then that document becomes a binding, sort of a working or living document. So what you said makes sense. This could be somewhat indefinite, but I don't think we run into any legal issues of indefiniteness, which gets into more philosophical questions.
When does it become non-binding?
Yeah.
I could probably add to that, again, working with insurance company that I have, they actually mandated that we put this in place, so I already have this in place. The one we have is probably close to 30 pages. And so this is pretty simple.
Yeah.
The contractors all have to sign it, and we have to do it every year, just like a certificate for insurance. The biggest thing that you want here is the fact that you're telling your subcontractor that you are responsible for an ocean inspection, basically. And if you've ever been to an ocean inspection, which I have because I have a subcontractor crews with a preference crews as well as general contracting, you realize that there's some value there. So this is a very valuable tool to have. You should not be general contractor remodeling or new construction out there without this in place.
Yeah, I think that was a good point, that this document does try to pick up that insurance responsibility and also the OSHA responsibility, which we, like I said, I think I'm seeing more of those in the last few years than I've seen in my past 25 years of experience. So it's
I've been in business for 25 years, 28 years, and we saw our first inspection last year. So you're
Yeah.
absolutely right there.
Yeah.
Our best ones up.
um,
At that point in time, this office will come to the general contractor, because the general contractor has liability as well.
And one other important point from both the trade contractor agreement and a shorter version, any arrangement, I think, needs to have a clause in there that governs corrective work and the responsibility for corrective work. So that's in the trade contractor agreement. There's a section on warranty and that the subcontractor warrants their work. One thing that I'd like to see, and there's maybe a little more teeth on how much time they have to correct their work, because especially if it's a sub that's in between trades, that you need them to come back in a hurry and repair something so you can go on to the next phase of construction. So you want to avoid delays. So I would say that we may want to look at that and tighten up the area about how long they have to correct their work. But I think in the warranty language, it clearly requires, them to promptly make repairs. And that's the only issue I have with the form, and I think we'll have to take a look at that in the next couple of years and see if we want to maybe try to put something that's a little bit more specific than promptly. But nonetheless, it is in the document, and and my client had put 72 hours, which may not have been terribly realistic in some cases, but if the subcontractor is on notice and doesn't correct their work for 72 hours, then the builder in that case could have fixed the problem themselves and kept on with the project. Let's see.
Absolutely. This is not like a one-on-one subcontractor. This is for somebody that's fully your partner. Because you're never going to get somebody to sign that that's doing business for you for the first time, one time, try out. They'll let you say you want what? And they're going to run to the hills. So this is really your partners, and you're establishing a partnership, you're agreeing to a partnership, you're saying, I'm going to do this for you, but this is what I need from you. And I'll give you a word. That's it. So
Yeah.
the annual thing is just smart to have a record every year that you go and you sign it, just like every year you get a new certificate of insurance. But again, you're reinforcing the fact that you're going to get insurance, you're reinforcing the fact that they're going to be compliant with OSHA, all of the above.
Do you use the addendums to do that every time you have a contract with them?
No, I don't. I actually don't do the addendums at all, because you have a signed proposal that you've agreed to with that subcontractor.
Yeah.
This is more just the understanding the rules of the road.
Yeah.
Like some builders might have a sign up that say, this is what we want you to do. And I really have a different way of doing that, but I'm surprised the more you have them hit by the insurance company. The insurance companies are really starting to mandate this too. Because they want to move that off the general contractor and make the parties that are there working responsible. If you have an expediter on a job site, and he goes on a job site and the guy's spraying and finishing, he doesn't have a mask on, and the carpenter's working with safety glasses on, and somebody's outside, they don't have a hard hat on, your expediter just walks through like it's a great day, and the OSHA guy's outside taking pictures. Guess what? And not only that, if one of those is considered a safety violation that's life-threatening, you've gone into a whole new level of fine. That's a days with you for the next 3 years.
Yeah, and I think he hit it on the head that a lot of these insurance-related things are definitely driving the bus, because I think the insurance companies, in addition to in the past few years beefing up their exclusions from coverage, they're also trying to avoid getting sued, so they don't have to pay people, attorneys. Even under the duty to defend, they can defer or deny coverage and say, well, based upon the exclusions and based upon your contract, the subcontractor should really run with this and take over. And that's, it's definitely a trend in the industry that while we kind of started out with this as a means of really apportioning responsibility and dealing with scheduling concerns, I think the liability aspect in the last few years has really crept into it quite a bit more.
You were doing it for one thing, and the insurance was doing it for another reason totally.
Oh yeah, well we know what the insurance companies are trying to do. It's, the fewer claims that they have to defend on, the happier they are, and the better their profit margins. So, and then ultimately, you don't want to be left holding the basket at the wrong time. So that's why these things kind of pass that responsibility to the subcontractor, so that it's spelled out and there can't be any misunderstanding about responsibility for insurance or OSHA compliance. And so you have the right to delegate OSHA compliance to a point. So I think that that'll help in the future to have contracts like this where the subcontractors have accepted that responsibility, or their insurance company has to become the primary carrier for any claims that come into play. But the basic gist, I think, stems from the idea of what we want to do is outline the essential responsibilities of the subcontractors and the relationship between the parties, the timing, the performance obligations, scheduling matters, and then the details of the work are all kind of come into play throughout the trade contractor agreement and the pricing addendum. And I think that no matter what you do in the future, I would certainly recommend taking away at least the bare bones or the meat of the trade contractor and supplier agreement and trying to put that into place, because ultimately I think while some of the subcontractors grouse at first, I think once they take a look at it and say, well, this really just puts into writing what we've been doing anyway, so maybe it's not so bad after all. And then I think the only burdensome things that they might open their eyes would be OSHA responsibility, which is there anyway for the subs. It just reminds them that they have to pay attention to OSHA compliance. And it also reminds them that they better have insurance coverage and provide the certificate of insurance to the builder or the general contractor as labeled in here. I don't really have any other points to cover on the trade contractor vendor agreement, but we'll have a few questions.
Yeah, you mentioned this before on insurance, about loss payee, additional insured. Can you define those two and what's the difference?
Okay, well, additional insured is something that the insurance companies have been bucking, especially in remodeling contracts, and naming the builders as additional insureds in remodeling has been difficult, and most insurance companies historically have not been doing that or really objecting to it. So
What does that mean,
additional insured is just, I think it's something more so for the insurance company's perspective than ours in the construction industry, but additional insured actually makes them an owner under the policy or part of the insured group rather than a loss payee. There's just we're splitting hairs, but I think from an underwriting standpoint, they cannot name a builder as an additional insured because the builder does not have an ownership interest in the home that's being worked on. And particularly in remodeling, that seems to be an issue. And we've talked with a couple insurance industry representatives who kind of have given us the language that has gone into the documents that we've come up with and presenting today. So ultimately, I view it as a matter of semantics and underwriting within the insurance company more than anything, but I think it's an important distinction that we have to keep in mind in practice so that we don't ask our insurance people for forms that they can't produce because some parent company, often Massachusetts, says, no, we're not giving you that. So that's why the loss payee comes into play, because that's more universally recognized in the insurance world. And I think that we can easily get those certificates, but we can't be named as an additional insured in many cases. So it's that's insurance industry driven too, but I think we've have solutions for those problems just by the verbiage that you'll see in the new home contract that we're suggesting as a form and in the remodeling contract that we're suggesting as a form. That kind of walks through the types of certificates that we would be looking for in favor of the builder, and also the similar language would apply to the subcontractors as well. So in your pack, those forms should be available. Mary?
The reason that you want to be a loss payee is that your name goes on the check when there's a loss. So when that check is written out, it's written out to the homeowner and you as the builder. So they can't just go and cash the insurance check for the work that you fix and you not get paid. That's why.
Obviously, that would be a good thing. You definitely want to be named as a loss payee.
I ran into the same thing you did with insurance company. I switched insurance companies, and they wanted this trade contractor agreement.
Yeah.
And of course, I didn't have one, so I asked them to send me one, and mine was not quite as long as yours. But even right in there, they wanted the subs to sign that they would be an additional insured. And every one of my subs came back and says, my insurance company won't do this. So then, this is real helpful.
Yeah, well, that's where sometimes it takes a lot of talking to the insurance agents and then kind of one notch up to go to the underwriters and have them straighten it out. And I've had to do that a few times where the local insurance people just don't know quite how to handle it. So if any other questions on this topic? Otherwise, we'll take a 5-minute break or so. Okay, why don't we take a break and we'll come back in about 10 minutes, please. I think we should probably get started on the next session now, and we'll try to wrap up by 4:15. All right. I think in the in the materials that were handed out, you'll find a change order and a notice of delay form. I'm going to go over a couple of easy forms and then tackle the warranty document. But the change order and notice of delay, I think, are very important tools in our practice. I think pretty much everybody here is familiar with them. The change order document that we've developed at the MBA tries to take into consideration things that come up along the way in a project where either through an owner selection or through a site condition, a change is needed in the scope of the work or in the cost of the project. So the change order, I think, is pretty self-explanatory, where we try to put into writing the reason for a change in the contract, the fact that the change might result in an increase in the cost of the project, and also in the change order we've added a section in there for extending of the construction time by a certain amount of working days. There's another blank to fill in that where you ask the customer to sign and return the change order to you within a certain period of time. The other aspect of this is, when does the customer pay the change order? Most of my clients will like to say that if the change is going to result in an increase in the cost of the contract, we want that change order paid right on the spot, or at least within a few days after the change order is signed by the customer, just in case we have to order materials or if we have to upgrade something. Again, the builder does not want to become the financier for the project. So I think that document goes hand in hand with the notice of delay form, which the notice of delay kind of came out of the remodeling industry, and we put that together in response to certain provisions in the Wisconsin Administrative Code that governs remodeling contractors. Essentially, this adopts the requirements of ATCP 110, which governs remodeling, and specifies what happens if there's a delay in the job. The notice of delay usually came about mainly because of the customers dragging their feet on making selections, or if there was an unforeseen condition. In either case, the administrative code for remodeling projects requires a written notice of delay, an explanation of the delay, and an estimate on how many extra working days it's going to take to finish the job. If there's an increase in cost, that also needs to be in writing, and the customer needs to understand why there's an increase in cost and what those increase in costs are for. So the notice of delay form covers all those things for remodeling. Frankly, I see no reason why a similar form should not be used in new home construction, because you really can then educate your customers that because of certain site conditions or certain selections or certain changes in the contract, there will be a delay in the completion of the project. There will be a cost frequently associated with that, and that cost needs to be borne by the customer. In this particular case, one thing I recommended this morning was, instead of using the notice of delay form, which seems a little onerous, I usually suggest to my clients that they put that in a letter and adopt all of the requirements found in the notice of delay. So we talk about the project, talk about the reason for a delay on the job, talk about the number of extra working days that will be needed to finish the work because of the delay, and in particular emphasize if there's any cost differences, they should be set out in either a letter or a notice of delay type form. The change order is designed to be more of a collaborative effort where the customer usually understands that they've upgraded to granite countertops, for example, and that they know that's going to be a price increase and they know they have to pay. And if it takes a certain amount of time to order that granite, then the customer needs to be made aware that it might extend the completion date for the job, just in case you can't work that into the existing construction schedule. So I think those two forms are important tools for the builders to use to educate the customers, because I think information is key in the construction process, of course. And I think some of the problems we see are a lack of communication or misunderstandings, where we don't have written change orders or we don't have a notice of delay. And so later on, the customer comes back and complains, well, you never told me that there would be an upcharge for that. So ultimately, the more we put into writing, I think the happier actually both parties will be at the end of the project. I don't know if anybody has any questions about those forms, and I was going to just move over to the warranty. Before I move on, though, I wanted to, Mary Schrader had brought up a good point that one of the reasons why the written trade contractor vendor agreement came about was in response to an effort by the state to tax independent contractors as employees for purposes of either workers' comp or unemployment. So a lot of times they'd ask our clients where, if these people are independent contractors, where's your independent contract? So that was another one of the reasons why, in response to state audits where they were tagging our clients for quite a bit of extra tax money, we helped to develop this form. So I wanted to thank Mary for bringing that to my attention too, because that was an important reason for the form. And now, of course, it seems to be more insurance-driven, but again, the creation of that independent contractor relationship, I think, remains important today. We have the last item is the residential limited warranty. This document is tailored more toward new home construction, but a similar document could certainly be adopted for remodeling contractors. The goal of the MBA in drafting this document was to kind of lay out what the one-year warranty really adopts or really involves. As many of you probably know, there's both an express warranty and an implied warranty. The implied warranties are that you're going to do a good job and you're going to do a project in good faith and follow industry standards. In our contracts, we say a standard one-year warranty, so there's the implied warranty. There is a 1 year of good workmanship. Now, the written or express warranty is set out in this form and is again designed to alleviate any confusion that existed in the past between the customers and the builders relative to what the responsibilities are under the warranty. I will caution that I think this document will be enforceable in 99% of all the cases. But one thing we do in here is we kind of relieve the builder of some liability that a clever plaintiff's attorney might be able to get around, because there are some statutes on the books where the state legislature has said that new home and remodeling contractors cannot draft a contract clause where they release themselves for liability for their own negligence. And we kind of do that in this warranty, but I think as a general rule it'll be enforceable. And essentially, here's why. This document basically adopts the standard 1 year warranty that has been in place for as long as home building has been around, or at least as long as I can remember, which is over 25 years now. And what we attempted to do was to put into writing a written version of the already existing standard 1 year warranty. So the term is, of course, 12 months from the date of completion. That's paragraph 1. Coverage, essentially, we talk about the builder warranting that the building will be free from defects in workmanship and materials, consistent with building codes and generally accepted industry standards. Now, that sets the table for trying to get around the homeowners who sometimes demand perfection. And I think we all understand that perfection cannot necessarily be achieved. And if the homeowner is out there with a micrometer measuring to the millionths of an inch, then this is not perfectly square. I have seen that in a couple cases. And in one case, and I remember in arbitration, I don't know, Bob, if you remember that, but we had a case where an engineer brought a claim and he had about 1,000 complaints. And he was mad at the builder and clearly went over the top and had a list a mile long where things that were out of square or out of plumb by like 1/16 of an inch, he made a note of it and it was one of his complaints. So I think the goal here is to put down in writing saying, we have to have a more reasonable standard than that. We have to pass code and we have to meet industry standards. Through the MBA, we do have the construction industry quality standards, which have been adopted after years of research and experience, and I think to some extent absorb some of the National Association of Home Builders standards. But again, these standards I think are more refined to our particular area of southeastern Wisconsin and take into consideration the standards of practice for good home builders in this area. So essentially what we're saying is we're going to provide you, the homeowners, with a warranty that lasts 1 year. It's going to be in good and workmanlike condition meeting the building codes and meeting industry standards. One thing I like in item 2 under coverage is that the buyer will not be allowed to withhold any money for items that are covered by the builder's warranty, which in some cases, I mean, we actually build in a retainage into our contracts for new home construction. Most of the time we try to avoid that because I think sometimes the homeowners are more emotionally charged than, say, in a commercial project. So sometimes the retainage requests are ridiculous. So the goal here is to have no retainage, and that's why in paragraph 2, if you use this written warranty, it does specify essentially that there is no money withheld for warranty work, or, you know, for that matter, punch list work. And I think that that signals to the homeowners eventually that they cannot demand later on that we're going to withhold $10,000 for an item that's going to cost $50 to repair. We have seen that happen, especially when some of the homeowners end up with a final draw that's pretty significant. You don't want a homeowner holding up the final draw for a couple of items that might be $1,000 to fix, and they're going to hold $50,000 over your head until you fix those things. The other thing I really like about this warranty, and I strongly recommend it, is the exclusions, because they're common sense exclusions, but not all the times do you see common sense out of the homeowners when they're upset and, as I said, emotionally charged. First off, homeowner maintenance and use responsibilities. On page 2 of the document, there's a nice list of exclusions. I've seen a couple builders who have longer exclusions and more explanation to really educate their customers on what the homeowner responsibilities are. I think those are great. I think they have to be carefully drafted, but I still think they're great because they're a very good educational tool for the customers so that they can't just think that, well, I can live here for 20 years and not do anything with this home. And so ultimately, a list of the homeowner maintenance responsibilities is a great thing because it educates them that if something goes wrong with the caulking, or if they don't properly do things like make sure the gutters are clean, that kind of stuff, then they can't come back barking at the builder for money or repair costs. There are construction-related exclusions, normal wear and tear. I recently had a case where I had a guy make a claim against my client who's a builder for a new home for damage done by his 2 big black lab hunting dogs, and he had one of those, I forgot, it's the deck, the exterior deck that's easy to scratch, and he had interior wood floors and really nice counters and cabinets. He allowed those dogs to run rampant throughout his home, and one time I guess we heard through a third party that the dogs were chasing the raccoon through a house one time, and this owner tried to make a claim against my client for all of that damage that was caused by the dogs, including damage to I don't know if it was an ironwood deck or one of those things where those are easily scratched. And so these are big black labs. I think one was 80 pounds, one was like 95. So normal wear and tear is not anything that we want to warrant, or dog damage for that matter either. The other thing I like in some of the contracts I've seen, and we do mention it here in section B2, is talking about warping or shrinkage of materials. I think I see hairline concrete cracks in every case I've ever worked on where the homeowners see a crack and freak out because concrete cracks. Concrete cracks and wood shrinks, and the goal here is to educate the consumers that that does indeed happen and that they can expect to see those types of things. There's a few other examples of ordinary wear and tear. Earth movement is an interesting one that's an exclusion. And I think once the construction is done, that essentially relieves the builder from liability for earth movement unless the builder has done something like improperly backfilled or driven some heavy equipment across the water line. Ordinarily, the builder should be off the hook once the project is done. Another important thing is at the top of page 3, if there's any work done by the owners, the stuff at the top of page 3 relieves the builder from responsibility for items that may have been defective work or actually damage caused by subcontractors that were retained by the owner. Sometimes the owners just don't seem to understand that if they hire somebody to do some work, maybe some cabinets, for example, and if they wreck some plumbing, somehow that still goes back to the builder. This document is designed to say, no, if you hired the cabinet supplier and the cabinet supplier messes up the plumbing, you have to go back to that cabinet supplier. And in our contracts now, we do say that we want the homeowners to prove up insurance for anybody that they hire. And I think those things work in tandem to make sure that the projects are protected and that your work is protected and that you require the homeowners to provide insurance, or ultimately they're responsible if no proper insurance is in place. Warranties that get transferred to the buyer, for example, HVAC, plumbing appliances, those things are responsibility that we're trying to pass through to the manufacturer. It doesn't always work, to be honest with you, because frequently if there's a problem with a product you supplied, you're going to get sued, but you ultimately would have to bring in the manufacturer. One of my examples I'm seeing pretty much every day is CertainTeed and their siding. Just got a call again on Friday about CertainTeed siding, where CertainTeed siding was installed and it shrunk, and it goes back to that batch that when CertainTeed was putting that out like hotcakes, they didn't allow their product to cure, and it went out for painting, went out into the field, was applied, and then it started to dry, and the CertainTeed siding, the cement board siding, has started to shrink. Here, there's a CertainTeed warranty, but there too, it's hard for the customer to get at that warranty, even though the warranty is passed on to them. CertainTeed is now saying they're only going to pay for replacement of material. They're not going to pay for labor. And I'm hoping they don't go bankrupt, because I've got like 8 more cases coming down the pipe for some builder clients where we're trying to get product at least replaced. So ultimately, the warranties that gets transferred to the buyer, while we say here that you can't come against us as the builders, technically that's not 100% true, and that's one of those little cautions that I threw out there as a yellow flag. But what we're trying to do is focus the attention on the warranty that's put into place. Same thing would apply for shingles. For example, if there's a shingle warranty or a window warranty, we want to go directly to the manufacturer, have them come out and assume responsibility for that warranty. So it'll always be good, no matter where you get your materials from, to check those warranties, make sure they're good, strong warranties, so you don't end up becoming a partial warrantor of some supplier's product. On E on page 3, then we have the actions outside of the builder's control. You know, a train derailment wrecks a house, it's probably not the builder's responsibility. Those types of things, acts of God, Mother Nature, etc. That helps to educate the customers, especially weather. Sometimes if there's weather damage, they somehow feel that that's the builder's responsibility, and as much as you guys try, I don't think you can control Mother Nature. We have here on page 4 the caution about mold and mildew and radon. That's section 4. This is more educational than anything, just to let the consumers or the customer know that these things are out there. I've seen quite a few mold cases where where the homeowner is basically scared into a claim against the builder when I think the experts who are credible will say, for example, we know mold exists everywhere. This is not an unusual amount of mold. You have to compare the inside mold to the outside mold, instead of the people that come in the space suits and scare the heck out of the homeowners. I mean, I had that in a Shorewood case recently where there was a little bit of a water leak and they had some mold showing on a ceiling, and the people moved out of the house for 3 months, and the mold report read like science fiction. And so the concern I have is that we need to educate the consumers that mold exists everywhere, and it's not necessarily going to be bad mold or bad for you. Sure, if there's a water leak, we need to address the water leak and stop the mold and maybe do some remediation. But it's generally, I have not seen any case, I'm not going to say they're not out there, but I haven't seen any cases in my practice involving the toxic mold, even though that's what people get scared of, because that's where the plaintiff's bar likes to make these types of claims and scare the consumers, and it's a hot topic for them at least. One thing we try to do is limit the remedies to repair or replacement at the option of the builder. That's in the middle of page 4. And we can disclaim some remedies, but we can't disclaim all of the remedies. And one thing that I think is important to keep in mind too is that while this is a 1-year warranty, it does not necessarily get the builder off the hook for any problems that arise or are discovered after 1 year. This is just the warranty. The statute of limitations for breach of contract is 6 years. And there are other statutes of limitations, technically called a statute of repose, that really extend out for 13 years. That's more for structural or latent defects. And those tend to be prorated type claims, and frankly not too many attorneys, thank goodness, know about them. But I have seen a couple of cases where we've even had some claims made at 10 years and had some recovery in favor of the homeowner or the owner of the property, just because some claims that are only discovered during the 8th, 9th, and 10th year after construction are still viable claims under this obscure Wisconsin law that I should not mention to any of my friends in the plaintiff's bar. One thing, too, even on item 7, it seems like common sense to allow builder access, but we've seen unreasonable demands over time for access to the property, where essentially we want the buyer to give the builder reasonable access during regular business hours instead of, Saturday from 11 a.m. until 11:30 a.m. to try to take care of some of these problems. We've put into this agreement the disputes and resolutions clause found in the home building contracts and the remodeling contracts. That's on page 5. The purpose of that is to further enforce mediation and arbitration as the homeowner's sole remedy for any breaches, just in case they decide to try to claim that this is a separate contract. This document is referenced in the new home contract, and it's adopted and incorporated by reference. In practice, I think it's important to have the customer sign it at the time the new home contract is signed. Even if, let's say we're building and selling a spec house, but if you get an offer to purchase from a customer, I think that the warranty should be made part of the offer to purchase, or at least an addendum or amendment to the standard offer to purchase for a spec house. But on a new home project, or for those remodelers who want to use a more extended warranty of this type, with remodeling, it's absolutely mandatory that an extended warranty must be signed at the time the original contract is signed. That goes back to that ATCP 110 rule again. For new home contracts, it's been suggested that these could be signed at the final closing, but I think you should really educate the consumer or your customers up front, have them sign this warranty up front. And as I mentioned before, I think that the more educating we can do to the consumers, the better off we will be as in the construction industry. And I've seen a wide variety of warranties, from the one paragraph one to the 10 or 15 page long ones, where there's enough detail and enough education about the different components of the home to really, I think, be a service to the homeowners, as well as a good defense to the builder at the end of the day, that, I told you at the beginning that, you're responsible for controlling moisture in the home, you're responsible for routine maintenance, and those types of things. This is, I think, one of the main points I wanted to emphasize is that the 1-year warranty is not a complete release of liability, but it goes a long way to limiting the exposure of the builder by allowing for the repair of defects to be the remedy of the homeowner rather than them bringing somebody else in. This combined with the right to repair law, if we always keep that provision in our contracts, at least it forces the homeowner to talk to the builder instead of hiring ABC builders down the block who will come in and charge triple what the work is really worth, and then the homeowner comes after you because they don't have any choice. So sometimes, I'm sure we've all seen that, where there's a $1,500 problem, for example, and then the builder gets pursued for $10,000 just because some builder took advantage of the situation. Nobody in this room, of course, but I've seen it happen a number of times where people will trump up these claims, bring in the mold experts, for example, and really try to ramp up their own benefit without really being honest with the consumer. So again, that's one of the reasons why I like the educational or the longer warranty, because I think you can really do the consumer a service by letting them know that the warranty is not only a one-year warranty, but then also explain their responsibilities, really lay out the exclusions, and basically kind of give them a roadmap for them to understand what their rights and responsibilities are relative to having problems fixed with the home. This is not necessarily pertinent to the punch list, because the punch list is a little bit different than the warranty. But what we would expect is that the punch list would be developed, at or about the time the home is just about ready for occupancy, or a remodeling project is ready for occupancy. And once the punch list is done, then the builder's responsibility sort of shifts over to be covered by the warranty. And when the warranty expires, then the homeowner's remedies are still limited under the right to repair law, which gives us a chance to both talk to the customer and try to still work out repairs, but that's only if we are sure that the problem is the builder's responsibility and not caused by some other source. So I don't have any I don't have any other comments on the warranty. Do we have any questions?
If there's a statute of limitations and it goes out for 6 years or 13 years in a structure, like you say, then why not write a warranty to cover those time frames instead of just writing a warranty for 1 year only, if ultimately you can be held responsible for 6 years or 13 years, depending on what you're talking about.
Because I think the warranty is more of a document that says, I'll come back and fix it so long as it isn't anything that you created during that 1 year span. So it's kind of a no questions asked. After the 1 year, then we start asking questions and go, whose fault is it? Is this a construction defect? And even under the warranty, we may ask that question, but essentially I think the warranty is designed to be kind of an insurance policy for that 1 year term. So I don't think we want to extend it past the 1 year, although I have seen people do that for foundations and other major structural components of a home, just because the consumers are most worried about the big ticket items. And that's where some of those insured warranty programs come in. While those are great, I don't find them, I think they're good selling tools, but the insured warranty plans seem to cover those things that really just rarely ever have problems. I know that doesn't fully answer that question, but that's my best shot at it.
You understand what I'm trying to, and ultimately,
Yeah.
from a legal standpoint, you're still responsible for it, so why not just cover it up front, give yourself a skill and go to the next.
Yeah.
I mean, that way you're also forcing it that if there would be a problem, you're still under contract because you put that warranty out in writing. It's still an arbitration case, not necessarily a legal case.
Yeah, well, the arbitration clause will survive the 1 year. I think we just added it to the warranty as a further reminder that mediation and arbitration must be complied with. And even the right to repair law will kick in, which is that enforced mediation, as I keep calling it.
They're still in place, even if it is a 6-year or a 13-year thing. It's still because that was the original contract. Both
Yeah.
of those are in play.
Yeah.
Okay.
Yeah. And that's been pretty well tested in the courts, so I'm pretty solid on that point. Yes, Bob?
Fred, this might be for you or other builders. When do you let your customers see the quality standards?
I think I have heard a multitude of answers on that. I don't think that it's really what you feel most comfortable with. I almost think it's better that you give it to them right at the beginning, if you're going to give it to them at all, because then it kind of helps to educate them that there are acceptable tolerances. And I think that's one thing consumers have the hardest time with, is that there's a give or take. It doesn't have to be perfect, and here's the industry standards that have been adopted after years of effort. I'd love to hear Mary's opinion on that. Mary is instrumental in the industry standards and helping to draft them, so I'm passing the buck quickly over to Mary Schrader. But the exact question is when would you give the industry standards to your customer? Would you give it to them at the beginning, at the end, or not at all?
It depends. So it depends on the customer. Some customers would never look at the book at all. Other customers sort of read through it, and you sort of have to, and pick out things to try, you can almost tell, you know, the ones that are gonna go through there and try and use it as a tool against you. Those I tend to keep it as tight to my chest as I possibly can and tell them that it's out there and it's in my contract. There's other people who just like information, and so that helps, like you said. And so I give it to them right with the contract signing.
That didn't really help. It's whatever.
What do you do, Dave?
I've given it out to people that I identify as
Right.
a potential need for it. But I can tell you, in the over 400 homes I've done, I've probably given out 5 books.
Yeah, that's what I'm thinking, you've rarely given out.
You give it out. The issue is that sometimes the standards get questioned. You know, I'm building with you because you have this reputation, so I want this. I want more than that. I want more than that. So ultimately, it's in the contract. It's a tool. If they
And I
request
use it
it,
as a tool to be, this is the minimum standard.
Right.
And we do a whole lot more than this.
right.
In this case, this case, this case. Concrete cracks, I can't stop it from cracking. And so we'll have that conversation at that time that I can guarantee you one thing, concrete will crack. You know, and so you know that you have that same conversation all the time.
You have that guideline. You can refer to it. The client asks you what those guidelines are. There's the book.
And then your
You know.
tough customer, I will send them a copy of that one part of it and no more. I don't even send the whole page anymore.
I've given out one in 30 years.
Nice.
I know, we always put together in our contract, where you're actually, when you're doing that, instead of, and not nothing here, you know, your full book, we addressed actually like the concrete cracking, you know, a couple main things. So, you know, straight up front that, you know, you can, 70% of your customers, if it happens, they're gonna ask that question and get that right out on the table instead of this here, kind of, as you said, this would be kind of a Bible for them to look through and actually just keep on going through the house until they find something that, hey, Randy, come back on over here, you know, so we addressed the main ones that actually sat and talked to them about concrete, about plaster, you know, all these other things, you know, that could happen, so that they know about it straight up front.
Well, and that's where I think that the written warranty comes in handy, where some of the better warranties I've seen, they'll list out some of those more common problems, list out the industry standards, and really focus on the document rather than giving the big book to, you know, use as a checklist. So I would tend to agree with that approach, and maybe educating them on some of those more frequent complaints that we get, particularly with concrete, and you know that. You know, and even during the construction process, I've heard a dozen times, I can't even count them, you know, stud walls, you know, these studs are not perfectly straight, you know, and so those kinds of things that you can show the customer, at least in the warranty document, yeah, don't worry about it, this is normal, it happens, you know, the finished product will be great. So I think I like your approach where you highlight some of the more important things. And ultimately, if you get it in the written warranty document, that's great, or have an informational piece for them. It seems to make the most sense to approach it that way. So I think unless we have any other questions, Mary has.
You know, you talked about the transferable warranties and maybe some loss act and all of that. By having a warranty like this and stating that those are transferable, does that help us at all keep out of trouble and not have to deal with a certain problem?
Well, the goal is to help keep us out of trouble, but ultimately the first stop that the homeowner will have and the homeowner's attorney will do is to contact you as the builder and say, hey, I have a problem with the certainteed siding, and we pull out the warranty and say, well, you're under warranty, and we'll try to get a manufacturer's representative out there. And then it depends how good the company is. I've seen, for example, Pella, I've seen them do really good stuff under their warranty or really bad stuff under their warranty. So it really is almost case by case, but I think ultimately we have to be prepared that as the builders we may have some responsibility at the end of the day, even though there is a warranty. If the warranty is not stood behind by the supplier or the manufacturer, then the contract was with the builder, so we're kind of stuck with kind of looking at it from both fronts.
How does that warranty come? Because I know something there again with the contract that he had. You know, you've got a customer sitting down and picking out different types of items and supplies for the year that this was an item in this type on, or we could put this type on here. Now there's a manufacturer warranty that basically, I think our contract alluded to something that manufacturer then steps in that it's not our fault that this one right, we're not able to come back to us.
If you act as the general contractor and hire the subcontractor, you're on the hook. If the homeowner, you're also on the hook if you sign that subcontract. Just because the homeowner picked out the supplier, if the subcontract comes through your company and you obtain payment and pay the sub in turn, and if you have any markup on that, I think you assume responsibility for that sub. Even with the product, yeah. Even with them picking it out. In order to get around that, you'd have to have the homeowner contract directly with the supplier, and then they become the general contractor and absorb that liability. So we're going to have to wrap up for now. I appreciate your time and attention and good questions.